What I do have a couple of problems with, though, does have to go along with the same kind of thing, and it's a matter of stewardship and back to basics and just remembering to count the cost. We're about set to go into mediation with the city over Bella Citta. In effect, we are going to be spending municipal money to defend the legal position of a developer. And I'm failing to see the greater good or what the city is going to get out of it, if other than bragging rights and claims of manifest destiny. What are we getting out of this? And shouldn't Bella Citta be paying its own freight? My impression is if the county is going to slam this down on us, oh well. And if Bella Citta wants to pay to fight it, then that's another story. But if they're not willing to foot the bill, all we're doing is using public funds to pay for a cause that should be paid for by the Boone Law Firm and by their client, Bella Citta. I'm not seeing dollar-wise. And this could go, you know, typical legal problems that we've had in the past have gone into the millions, assuming that we even go $700,000 on this one with consulting attorneys, et cetera, and all of the staff time. What's the dollar amount that we're getting back out of this? And I'm just not seeing it unless Bella Citta wants to foot the bill on that. And to me, it's just public money for private purposes at this point in time, unless you can make some declaratory argument over the greater good that I'm not seeing.
Mr. Mayor, City Council members, Jeff Boone, a Venice resident since 1958. I'm here to, actually just wanted to talk about the airport real quick, but since Bella Citta's come up a couple of times here, I want to address that too. But first let me just say on Bella Citta, I agree. In fact, John about fell out of his chair. I told him I agree with him to some degree that this is a colossal waste of money on Bella Citta. I'm the attorney for the developer's my client. And what I don't think John knows, though, is that my client was willing to spend the money to have me and some of the other consultants on the consultant team make a presentation to the county commission about Bella Citta, because they formed their opinion, the county commissioners, as to whether there's a compliance with the county's compatibility standards or not, based on what anti-growth people have told them. And they refused our offer, written offer, to make a presentation to them to give them the facts. So my client was willing to spend the money to cut this thing, to head this thing off at the pass or nip it in the bud months ago, and that was rebuffed. And there's no way to force the county commission to hear a presentation if they don't want to. So I think if there's any concern about money being spent, this is the wrong local government board that complaint should be directed to.
The other thing, now, as far as the idea of the JPA and paying for the developer, I just want people to understand, when we question this, we spent an unbelievable amount of time creating really an historic document. But when you create something that's a one-of-a-kind, first time out, it's not 100% perfect right off the bat. And what we're doing right now, it doesn't matter if it's Bella Citta, it doesn't matter if it's a roundabout. What it's doing is defining what does that document actually say. And that's what we're in the process of doing. I think it says one thing, maybe a county commissioner thinks it says another thing. We have to define so that we make sure we're both on the same page. That's what we're doing. We're not fighting for the developer. We're setting what does the JPA actually say. We have a disagreement about that. We have to settle that. That's what we're doing.
John Patten, I just wish to rebut Mr. Wilson and Mr. Boone just a bit on the Bella Citta. Mr. Boone stated that his client had been willing to put up the legal fees for the Boone Law Firm to go and make a presentation to the county commission. That's all well and good, but that has little impact on where we are now. And as to Mr. Wilson's statement that we need to hammer these things out and we need to address these issues, that's true. But that's a manifest destiny argument. And we're not the aggrieved party. An example.
The dispute that is currently in alternative dispute resolution under Section 10 of the joint planning agreement, that is an agreement between Sarasota County and the City of Venice. Bella Citta is not a party to that contract, that agreement. The dispute is between the county and the city over the interpretation of Section 11I of that agreement. Bella Citta, the only way they're caught up in this is their project has generated the dispute. But it is not a dispute involving Bella Citta. It's a dispute between the city and the county over the interpretation of an agreement between the two parties and how it applies to not only Bella Citta, but any future development project that may fall under 11I. To say that Bella Citta should be picking up any portion of the expense of alternative dispute resolution just doesn't understand the legal effect of the document nor the current dispute that's being addressed. So this is a dispute between the city and the county, a two-party agreement that the parties signed. I agree with Mr. Wilson. This is an historic document. This is the first document of its kind in the state of Florida. A ton of effort went in to get us to where we're at. But like every agreement that's first out of the box, there's a learning curve, and you're going to have some tweaks, you're going to have some misunderstandings, and you're going to need some interpretation and maybe even some revisions or clarifications of the language. But really, this is not a dispute between the city, the county, and Bella Citta. It's merely between the city and the county over interpretation of the agreement. And we're working through it.
Thank you.